All right, folks. So our last panel of the day, we're going to be exploring the ASC's opportunity to discuss our investor protection efforts, developments, and emerging areas of focus. We will welcome audience questions and we'll build in some time to respond. Any questions we don't have time to consider during the discussion will be responded to by email, so please do include your email information if you submit a question. At the outset of the event earlier this morning, I mentioned the two foundations of our mandate: fostering a fair and efficient capital market and protecting investors. We've heard some excellent discussions earlier today about capital formation, opportunities for Alberta, increasing productivity, and the role of innovation in diversifying the Alberta economy. As I said for our last panel discussion, we're going to focus on investor protection efforts at the ASC. Now, we won't be able to talk about all aspects of our efforts to protect investors, but we will hit a few key areas that are informing our regulatory work, including how we consider the impact of technology, developments in compliance and enforcement, and different methods and avenues for education. Now, personally, I always find it important to set the stage, no pun intended. That is to reiterate why the need for investor protection is so important. We've heard already from some of our panelists, and indeed from Trevor as well, that educating investors about capital markets builds understanding and facilitates participation, while informing capital market participants of the rules of the game decreases friction. These are positive benefits for all of us collectively and individually. Conversely, bad actors harm investors, deplete confidence in the capital markets, and divert capital from legitimate businesses and investment opportunities. These are all negative outcomes for everyone in this room. Allow me to illustrate the latter point by referencing one of our current enforcement cases concerning a company called Black Box Management Corporation, which Cynthia will speak to in more detail a little bit later. A single unregistered person deceptively courting investors and claiming that he could enrich them through day trading raised $150 million from more than 1,000 investors in a relatively modest period of time, about 3.5 years. Unfortunately, he was running a Ponzi scheme that resulted in devastating losses to individuals and a huge loss of capital for legitimate investment purposes. It's the prevention and condemnation of these activities that, in part, inform our investor protection efforts. So with that lighthearted beginning, we're going to start at the life cycle, or the beginning of the life cycle of our investor protection efforts with education. And I'm going to ask Hilary, Lynn, and Katrina to speak to industry education, investor education, and our own internal ASC education. Hilary, I believe you have the honor of starting us off.
I do. Thank you. Thanks very much. So industry education, sharing information with industry is a priority for us. And why is it? Because whether we come out with new rules or changes, we want to share that. And we also want to share what we're seeing in the marketplace. So some of the things that we do in brief, speaking at a high level, we do information sessions, webinars. We also publish reports, our Capital Markets Disclosure Report, our Energy Matters Report, and our information sessions that follow. We do webinars. We're working very hard to enhance the information that's available at asc.ca, because we know that there's lots of small businesses and smaller enterprises, like the folks that we heard earlier today, who are seeking information, and they don't necessarily know how to follow or dig into the securities law and policy section of our website. So we're trying to make things more accessible. So at a higher level, that's what we pay attention to, is trying to engage, try to share, try to provide timely information, and in a variety of ways, both in person, virtual, not unlike today, actually. So, but that's at a high level. Lynn, do you want to dig in a bit more in market regulation?
Sure. So in market regulation, we hold educational seminars for our registrant community to help them understand the rules and our expectations. Because if we can help industry understand the rules and how we're interpreting them, then registrants may find it easier to comply. Since we started providing educational seminars to our registrants in 2013, we've tried to tackle the hottest topics: new law, new guidance, how to get through applications and some other requirements of registration, and reviewing common examination findings and disciplinary actions so the community learns from mistakes that others have made. Our educational efforts don't stop at the seminars. A big part of our job is to get out and examine a firm's business conduct and financial compliance, and we report our findings from these examinations to the firm. We carry out examinations in part to detect non-compliance, but our examination reports also hold educational value. Our examination findings are tailored to the firm's business. So firms probably don't realize they're receiving a valuable service from us, but it is a unique training opportunity for the firm. Finally, we invite community representatives to our advisory committees. Our advisory committees provide us the opportunity to speak directly to our regulated community, and we get to educate each other. We hear issues from industry. We talk about new policy and trends we're seeing in compliance and business in general. And just tangentially, a little bit outside our educational initiatives, I want to say that good advisors have key roles in investor protection because good advisors educate their clients about investing. We heard directly from investors when we held focus groups in 2016 that working with their advisor increased their knowledge and confidence in investing. And this is part of the value of advice and part of the value of having a regulated environment.
So the third piece of our approach to education as an important investor protection tool, and really an important tool in executing the entirety of our mandate, is internal education within the ASC. Over the past year, we've really focused on staff education in order to continue to develop existing staff, train new employees, and generally cultivate thought leaders within the ASC. Our Advanced Research and Knowledge Management Division has developed training programs in securities law fundamentals and making Alberta securities law and policy, as well as division-specific training for operational staff in different departments at the Commission. We recognize that people come into the ASC with varying backgrounds and expertise, and we appreciate that the delivery of regulatory services is a unique business. So we've really put a lot of effort into the internal training and also training on current topics facing our capital market, many of which we've talked today: developments in fintech, evolution of technology, issues around the use of AI, and topical international legal and regulatory developments. And of course, another important element of internal education is making sure that our staff is tied into what is important to our stakeholders in Alberta through various forums to engage on current policy initiatives, engagement with our ministry, and through our advisory committees. All of this is aimed at ensuring that our work is informed, responsive, and that we can always bring a regional voice and perspective to what we do. We think that all of these internal education efforts that we've been unfolding over the past year plus are really important to ensuring that what we do as regulators is deliver solid work that's technically sound and demonstrates market awareness, and also that we're evolving and we're able to pivot when necessary. We're accessible and intelligent regulators because that's what we think the market deserves.
And I think the last piece is investor education. Samir, that we would have covered under education. Investor education, you've heard numerous panel discussions today, right? The market's changing, investors are changing. We certainly see that. We do our own research to understand, and we also are part of the Canadian Securities Administrators, the CSA, and we do a regular investor index survey there as well. And I would say we also work closely with enforcement to understand the Canadian Anti-Fraud Centre data as well. And I think, and please correct me if I'm wrong, Cynthia, but what we know today is just about every age group in every part of Canada is vulnerable. So we have younger investors that are just starting out. They may be as young as 18, and And as the last panel talked about, they're following social media. That's where they're getting a lot of their information from. They don't have the ability to access advisors, but they're interested. They've heard a lot about the importance of investing from their family members, from their parents even, and they want to get involved. And they're trying to figure out how to do it as safely as possible. So they're following their influencers on YouTube and other places. And then there's the middle-age group. And some of them may do some do-it-yourself investing, like the younger group. They may be a hybrid. So they have an advisor, but they also dabble in it a bit on their own. And then there's seniors, many of whom have advisors. This entire population, all these age cohorts have different needs, different knowledge, understanding, different understanding of business, different understanding of what investing is. And there's also a group that we've seen more and more of in the last year or so, and I'm going to call it this, and I don't mean it disrespectfully, but the accidental investor. So this is the audience that they didn't plan on investing. They wouldn't define themselves as an investor, but they're really trying to find how to grow money, how to find money. They are inflationary pressure, maybe their job situation, whatever it is, they're looking for money. They're online, and they're seeing these opportunities pop up and get sold to them as an opportunity to make money, and so they dive in. So they may not even define themselves as an investor, but they're there, and they're now involved in something which may or may not be a scam. So it is a wide, and I didn't intentionally leave out new Canadians who don't necessarily understand our systems. Some of my team members have been educating me that some of these new Canadians come to the country where they lived before, they couldn't even have their own bank accounts because of the way their culture worked. And now here they are, they can have a bank account and they can invest, but they don't necessarily understand how the system works. So we're talking about a very diverse group of people that all need knowledge. Knowledge gives us the ability to make the right choices. And I don't think it's just the securities regulators that has a role to educate. I think all of us in the ecosystem have a role to play in educating, whether that's advisors, like the group you're talking about, Lynn, or banks, and all of us play a role. And for us at the ASC, we try to do in-person classes, virtual classes. We are also trying to share information, make it accessible to them, and also trying to put it where they're searching for the information. So search engine optimization, search engine marketing. Right? When they're out searching for different things, we're trying to feed information to them so they come to unbiased sources of information, which is what our websites provide. So we look at education at a very broad spectrum.
That's great. Thanks very much, Hilary. Lynn, you touched upon something in your comments, in particular, going out to see registrants, speaking with them, trying to educate them about the regulatory regime, how they can comply, what the intention is. You talked about it being perhaps a hidden source of training that was not necessarily obvious to them. Like probably at the first time they've ever heard someone say that, but I think it's actually a very astute point. Perhaps you can speak a bit to some of the things that your registrant regulation department does in going out and conducting some of these reviews.
Okay, yeah. So our investor protection efforts start with our registration team. They vet firms and individual applicants according to 3 criteria: proficiency, integrity, and solvency. They recommend whether to accept an application or reject it. And applicants will generally exit the process if they know they do not meet the criteria. But if rejected, an applicant has a right to hearing. And we've gone to hearing once. The applicant did not appear at the hearing, and the application was rejected at hearing. And then subsequently, our enforcement division, in a completely separate action, took the individual to court for illegal trades and distribution of securities, and he was sentenced to 9 months conditional sentence and a 7-year ban from acting as officer or director of any issuer. So that was an interesting example of how market regulation and enforcement both have critical roles to play in investor protection at different times. But successful applicants are registered, and then they're permitted to provide services to investors. They're subject to rigorous ongoing conduct and financial requirements as registrants. And our registrant oversight department oversees our registrant community to make sure they're complying with their registration requirements. We monitor solvency by reviewing audited and interim financial statements and regulatory capital filings. We monitor business conduct by carrying out an examination program which tests compliance with the rules. We apply a risk-based schedule where higher risk firms are examined more frequently than lower risk firms. And we also perform examinations for cause if we receive complaints or if we see red flags for non-compliance. We also perform examination sweeps on topics of interest. The OSC and CIRO, you might have noted, have just announced a sweep of the bank's sales practices that they're leading on behalf of the CSA. Another big area of investor protection is our policy work. And when we put forward new policy, we recognize that implementation is important. So for example, before new rules go into effect, we found that striking implementation committees that include representatives from industry and other stakeholders has been successful because participants have the opportunity to ask questions about the rules and identify potential issues around implementation, and the committee works collaboratively to answer the questions and deal with the issues raised, and then we get some guidance out publicly. And then once the rules come into force, we get out to do examination sweeps and see how registrants have implemented the new rules. We publish the results of the sweeps, get more guidance out, and in Alberta, we view this as a level-setting process where we're trying to ensure everyone is on the same page. This type of process is currently underway with 3 of our investor protection projects currently in various stages of implementation. So for client-focused reforms, it's a great example of this process. The client-focused reforms are requirements which were introduced in 2021 to promote the concept that the interests of the client should come first in the client-registrant relationship. And we're almost finished with our second examination sweep, which covers the new requirements concerning know your client, know your product, and suitability. We expect to have some results and guidance out in the spring of 2025. Then the elderly and vulnerable investors project, our objective with this policy project was to improve protection of older and vulnerable clients by providing registrants with tools and guidance to address situations involving diminished mental capacity or financial exploitation of their clients. And so the definition of vulnerable client is being reviewed to see if it's broad enough for what we had intended. And we're doing a retrospective review of the use of the trusted contact person and the temporary hold concept. Total cost reporting is a brand new policy project which improves investor awareness of embedded fees associated with their investment funds by mandating enhancements to the reports that registrants currently provide to their clients. The requirements for segregated funds in the investment industry have been closely harmonized with the securities-based investment funds, so there's no regulatory arbitrage. So we have an implementation committee struck, and we're working toward the effective date of January 1st, 2026. And then I wanted to just mention concerning crypto asset regulatory framework. You may have seen that we've issued press releases indicating that our intermediaries in this space, the crypto trading platforms, are to be registered with CIRO. So some of them are registered with us, some of them are operating under pre-registration undertakings, but all that goes away and they are going to move over to the CIRO platform. And we continue to look at our regulatory framework for crypto and consider policy as appropriate. For example, value referenced crypto assets or stable coins requirements are currently under discussion. They're currently hotly debated. News on that soon, I think. And Hilary, whenever we do policy work, communications has a key role, right?
Yeah, it really does. And my colleagues here from the CSA It's a collective effort. I chair the committee, the National Committee on Communications for the CSA, because we're really trying to go beyond a news release, a simple news release to explain what we're doing, to use social media where we know people are, and to provide information sessions locally as well as at a national level. So it's not enough that we publish these things. It's really about making sure that the right people hear about it and understand it. So that. Thanks.
So, and then when we do policy, we communicate policy, the question is, and we undertake all these other educational initiatives, the question is, does it work? And so when I started at the AAC in 2011, registration reform had just become effective. This included new regulations imposed on previously unregulated intermediaries of private financings. So the exempt market dealers were a brand new category of registration. And so in 2011, 2012, we did a high-level review of our EMD community to learn about their businesses. And in late 2014, we started an in-depth examination sweep where all Alberta-based EMDs were reviewed for compliance. And that was known as the EMD sweep. We published results and guidance in 2017, and throughout that 2014 to 2017 period, we took a range of disciplinary action in cases where firms did not meet expectations. And then we did a check-back review in 2018 to retest those EMD sweep firms that showed the lowest levels of compliance. And in 2020, we asked ourselves, has all this activity worked? So we did a retrospective review of the effect of our education, oversight, and disciplinary measures on the exempt market since registration reform. And that review showed that our actions resulted in a significant improvement in investor protection. 30% of the original EMD sweep community significantly improved their compliance. And we know that because we saw the before and we saw the check-back results. 25% of the sweep population left the industry, mostly as a result of disciplinary measures. So non-compliance was stopped and either successfully remediated or stopped permanently. And now we are left with a community who wants to comply.
Okay.
It's great, and thanks for that. I think it's important it's one of the things we've heard before is you put policy in place, you have to come back and test and see if what you're doing actually makes an impact and has the intended outcome. So it's great to see that that was done by your group. I want to touch on something that has come up in the broader context. It was a discussion that was had on AI and its usage and risks in the market. We're going to narrow it down a little bit to broaden it one way and narrow it another way. We're going to talk about all technology, but we're going to talk specifically about how it helps and can hinder investor protection efforts. So, Hilary, you did mention earlier that we do try to collect some data because I think it's important. We understand evidence-based policy and decision-making is critical. Maybe you could speak to some of the research we have on this in particular regards investor behavior.
Yeah, sure. No, thank you. So as we talked about, technology is certainly making it more accessible for a large number of Canadians. And the investor index, the CSA investor index, told us that, and this was done in 2024, earlier in 2024, over 53% of investors today are using social media as their go-to source of information. YouTube being the most common of all the social channels, despite the previous conversation about some of the other ones. YouTube is by far and away the most prevalently used, but I do want to accentuate 82% of that younger cohort, so 18 to 24, and even bridging a little bit higher, 82% of them use social media as their information source for investing. So, and we also know that 50% of Canadians, on average, that they're encountering investment opportunities through social media channels. So technology is prevalent, and and how people are interacting with it is really impacting, which I know Cynthia, you'll talk about it a bit more, but first I think it's up to you, Katrina.
Yeah, I think some of the comments in the previous panel really teed up this section for us very nicely.
Yeah.
I think with all the benefits that technological advancements bring, it's hard to deny that this proliferation and expanded communication channels nowadays that people use have also brought various types of harms. Anyone with teenagers knows all about this, constantly on their devices and consuming information that way. It's the whole, I want it now, and I want it on my phone. So the way I feel my son behaves all the time. This is also true in the context of financial services and how young people especially are accessing information and accessing financial services. I think in the prior panel, Hans used the phrase binge watching cocaine-induced investing, which I thought was a hilarious description to describe this phenomenon that we're talking about. Two areas of regulatory interest for us right now, and myself and my team in the Office of the General Counsel are considering these. And these are a couple of things largely enabled by technology that we're observing. One is promotional activity, and the other is digital engagement practices on online platforms. In terms of promotional activity, this is an area that's really changed over the years with technology and the ubiquitous nature of social media. There's so many platforms for people to instantaneously connect with a community, with millions of other people, and make their views known and often affect behavior, including investing behavior, as the data points out. So as regulators, we have an interest in ensuring that investors and the integrity of our markets are protected in the face of all of this communication. It's important that investors know the source of promotional communication, including any interests that the promoting party has in the company whose stock is being promoted. It's important that the communication isn't misleading or being done for ulterior reasons, purposes which could compromise market integrity. Our existing framework in Alberta imposes requirements in respect of engaging in traditional investor relations activity, which is defined to be communications by or on behalf of an issuer that promotes or could be reasonably expected to promote the purchase or sale of those securities. But it doesn't contemplate promotional activity not being done by or on behalf of the issuer. So therein lies a bit of an issue when we look at the evolving ways people are communicating and promoting these days. In many cases, nowadays, the issuer may have no idea that the promotion is going on and has nothing really to do with the person promoting it. Should we be concerned about this more expansive type of promotional activity? In easy examples, a social media influencer or a finfluencer may be getting paid by an issuer to use their celebrity and social media following to attract attention. So we all likely heard about the Kim Kardashian dust up with the SEC when she violated U.S. anti-touting laws for not disclosing she was getting paid hundreds of thousands of dollars to post about a particular crypto asset on her Instagram feed. In other cases, a person engaging in promotional activity may have a financial interest in the stock. They may hold shares in the issuer, and they could benefit if the price goes up or if the price goes down in the case of short sellers in the market. Or they may be receiving compensation from an external third-party source, payments for clicks or ad revenue on a social media platform. Should these kinds of promotional activities sort of across the spectrum as they've evolved be subject to requirements to disclose these personal interests or these benefits? Should these types of promoters be held accountable for misleading information being spread in the market that potentially interferes with orderly trading? Or maybe the person isn't receiving any identifiable compensation or financial benefit, but they have strong personal or social views against an issuer's business and want to discourage growth of the company for those reasons. Do we care about that? If our job as securities regulators is to protect the integrity of the market, it would seem that we should be considering the effects of all of this communication happening in this day and age, while being very mindful of the need to strike the right balance in addressing the activity, including ensuring that any limitations or restrictions are appropriate, that they minimally impair people's rights to speak freely, and that they're in the public interest. I think, Cynthia, perhaps you have some things to add on the enforcement side on this?
So from an enforcement perspective, we're seeing what Katrina referred to with more social media influencers, or these finfluencers. We saw them initially south of the border. Kardashian's a great example of a big name headline. We have seen that trend move into Canada. And right now, with securities legislation, we have a grasp over the conduct of certain influencers, those who are engaged directly or engaging in these activities on behalf of an issuer. And so we have brought our first enforcement action in this space this year. We issued notice of hearing earlier this year against an individual named Jay Floriani and his company, Jayconomics, where the staff alleged that Mr. Floriani was compensated by a number of different issuers to issue social media posts on social media platforms like YouTube, X or Twitter, Patreon, and wasn't disclosing the fact that he was being compensated to issue these posts. You know, at its core, there's an issue here of not just in this particular instance, but more broadly with influencers. Is there a conflict of interest? And is that conflict of interest being disclosed? And if not, is that putting the investing public at a disadvantage by not having information that is relevant and important to people in making that investment decision? So this is the first enforcement action we've brought in this space. I certainly anticipate it won't be the last.
And maybe, Samir, before we move on from this topic, the last piece on technology, benefits and drawbacks that we're seeing in terms of investor protection. Just mentioned briefly digital engagement practices, which we often hear the term gamification on online investing platforms. So these digital engagement practices are practices that use specific behavioral techniques enabled by technology to attract users and affect behavior on the platform. Things like social interactions, information, copy trading information, leaderboards that show how others in your community are performing and succeeding. We heard from one of the AI panelists this morning how much AI is being used to customize these platforms and these techniques. And this is how, he also mentioned how this is truly how the majority of people, especially young people, are participating in the market. And of course, a lot of this phenomenon is positive. More people are getting involved in the market, participating, taking control of their finances, increased access, more financial literacy, more liquidity in the market. All these things can be very positive. But with this phenomenon and these practices comes emerging sort of investor protection concerns. Worst case, of course, is when these techniques are used by fraudsters to suck people in. But we've also seen that some of these practices can encourage excessive trading, impulsive decision-making, and this can have real financial consequences for people. And this is an area of regulatory focus everywhere. IOSCO has recently launched a roadmap to enhance retail investor online safety and has released a number of consultation papers to look at emerging investor protection risks involving these types of digital engagement practices, and one of which is copy trading, which I had to read up on a little bit, and it's effectively an imitative strategy, trading strategy that is intended to allow retail investors who are called copy traders to automatically replicate the trades of more experienced or professional traders or lead traders. And it's marketed as a way for retail investors to participate easily in the markets without the need for extensive investment knowledge or active, consistent decision-making or expensive investment advice. But these strategies are often associated, the data shows, with short-term high-risk trading strategies, often involving complex products, volatile products, which aren't sufficiently understood by many investors. It's easy to see how some of these tech-driven digital engagement practices appeal to young people who are used to consuming information differently and who've grown up in a world of retailers vying for their attention on various platforms using various types of these techniques and gamification. But the consequences in the context of employing these in purchasing investment products can be a lot more significant. One stat I found interesting that I'll share in closing came out in a recent OSC study on the use of digital engagement practices on these platforms and the effect on retail investing behavior. And they tried to measure the extent to which people traded things that were the subject of these types of features on platforms. And the study showed that people invested 12 to 18% more in stocks or financial products that were presented on these platforms using these particular types of techniques, particularly the copy trading and social interaction themes. So I think there's a real need to continue looking at this use of these practices and make sure that these techniques aren't unduly compromising investor protection, but still recognizing the positive aspects that I mentioned and not overreaching or deterring innovation in the space.
Thanks very much. Before we leave this topic, there is one thing I wanted to ask, because we did talk about helping and hindering. We've talked a lot about the hindering part, maybe not so much about the helping part. One, and in fairness, access to information in general is good. Access to accurate information is even better. That's something that I think the social media morass is continuing to try and filter out and figure out how you can make it clearer. But there is the use of technology by us in terms of making sure that we are getting our message out. So Hilary, I think we've got a couple extra minutes. I wonder if you might just briefly talk about some of our own attempts to utilize technology to try and ensure that a balanced perspective or positioning ASC as an area for getting unbiased information, something we can do to help contribute to a more balanced discussion utilizing technology.
Absolutely. Thanks, Samir. Yes, technology can be a friend, not just a foe.
I hope I didn't imply that it was just a foe.
No. But I would say collectively, and I've talked about the risks as well, right, for the investors that we're talking about. So in terms of the things that we're trying to do, so as you can imagine, it's sometimes tricky to make regulatory policy sexy. But we are trying our very best with things like video content, and in fact, we did when we put out the OBSI regulatory project. We actually had our chairs, Darren Magatsu, who's the chair of the CSA, and our chair here at the ASC. We did a video to just talk about it very simply, so that we can push that out to the audiences that need to hear about it. So that was the first time we'd done something like that, because we recognize that video content, right? YouTube is the most popular. Video content is what people are looking for. So we're trying to use that. We're also trying to use that with our investor education team here at the ASC is going to be using a new platform to try to reach different communities in Alberta, because it's not enough just to talk through social media, right? We want to be present, and it's hard to be present around the province in different markets. We happen to know from our own travels, Tony Fleming has traveled up to the Grow the North conference in Grand Prairie. We know that Grand Prairie folks love crypto, but they don't necessarily have access to unbiased information about crypto. So our investor education team here is working with the new vendor to actually do something of a telephone outreach, but a presentation through the telephone, through phones, right? Not old school telephone, but our digital phones, our
Yeah, that's not the
smartphones.
technology I was thinking about. I was thinking Alexander Graham Bell technology. I was thinking.
No. Using modern technology, we're going to reach out to Green Prairie residents and invite them to an information session on investing in crypto, what you need to know, what you need to be aware of, why it's high risk, those kinds of things. So, it's intentionally to be balanced, provide balanced and unbiased information for these folks because we know that they love it. We know that we got inundated with questions about it. So we're trying to use different channels, different ways to reach people using technology, whether it's through social media, whether it's through new products. Let's face it, after the pandemic, we had to shake things up and do things virtually, which we had not done prior to. And now we do virtual information sessions for all kinds of audiences. So does that answer your questions?
Yeah, no, I think that's very helpful. I just wanted to make sure people didn't think we were a bunch of naysayers up here. We do see the value of technology, and in fact, we utilize it ourselves to try and achieve our own goals. So maybe I can move us on to the next topic, which I think is, as I said, we've got this narrative of this arc. We've talked about education of investors, education of our market participants, moving a little bit more strongly into gentle force applied to get compliance. And then we get to the back end where folks perhaps need something a little more than a gentle push to get to being on side. Talk about compliance, discipline, and accountability. And I think, Lynn, maybe we'll start with you, and then I think we'll move on to Cynthia after that.
Yeah, in some cases, due to the significance of deficiencies found in the compliance reviews or through financial compliance program, we take compliance-related actions in order to protect investors. But there's a spectrum, and it goes from light touch all the way over to enforcement. So on the light touch side, we may issue warning letters, warning that if a compliance issue is not fixed, we may refer a matter to enforcement. We may ask for enhanced informal compliance. So rather than formally placing terms and conditions on the firm, the registrant voluntarily agrees to do certain things like maybe report financial statements to us monthly instead of annually because maybe they've filed late a couple times. Then, as it gets more serious, we may impose terms and conditions on the registrant formally. These terms and conditions could require the firm to retain a compliance monitor to help the registrant correct deficiencies that were discovered during an examination. The terms and conditions could include additional reporting to staff or restrictions of certain activities for a limited period of time. We might have compliance settlement agreements, which are a joint market reg and enforcement action where firms admit to past misconduct and commit to future remediation by way of terms and conditions on registration. We may, in very serious cases, suspend or terminate the registrant's registration. And we may refer registrants to enforcement for further investigation if we see serious investor harm, and this may happen even if we've already suspended the firm's registration. One example of compliance-related actions taken by ASC staff arose out of an EMD sweep examination together with ongoing financial compliance oversight. The compliance review showed that the registrant firm was significantly deficient in many areas. And to address these compliance concerns, a compliance settlement agreement was entered into with the firm, whereby the firm acknowledged past breaches of securities laws, agreed to a specified monetary payment to the ASC, and agreed to retain a compliance monitor to oversee the firm's operations for a minimum period of time. Eventually, due to other factors, including a cyber attack, this firm did leave the industry. So that's an example. Cynthia, more on enforcement?
Okay, thank you then. I have the distinction of being the last panelist to speak on the last topic of this afternoon, so thank you all for your rapt attention while we persevere. If you can get your phones ready, please. There are 3 different things I'm going to ask of you. So the first, if we can pull up the Slido question for the audience. And this question asks, have you ever been approached with a fraudulent investment opportunity? Or you might think of it as an investment scam.
Yeah.
Give you a moment to answer that. We're looking like we're in the mid 60% saying yes, 28% saying no, 11% unsure. Interesting. Interesting, the question that I posed was, have you ever been? If I were to take a guess in this room, I would say almost 100% of us have been approached with an investment fraud in the last week. We just don't necessarily know it. And that is how prevalent investment scams have become in Canada and in many other parts of the world. When we're looking at investment fraud, obviously different types of investment fraud and scams are just one of those. But this is an area in Canada where we really need to be paying attention. So why do I say I think many of us in the last week have been? If you have a mobile phone, you very likely have received a text message from someone you don't know. You may have received a phone call from a number that looks a lot like your cell phone number. You may start with the first 3 digits of your cell number. Is this ring true for anybody? Yes. These are investment scams trying to come to you. They're coming at us from a myriad of different ways, and they're becoming increasingly sophisticated. So I say that sort of to get us thinking about how prevalent they are and talk about some of the things that we're doing within enforcement. So that was the first thing I wanted you to do with your phones. Thank you for obliging. The second thing is, because we're nearing the end of this panel, we will have time at the end for questions. So please, if you have questions for anyone on the panel, please use Slido or the slips of paper on your table and submit those questions to us, and we'll be happy to tackle those. And the third, just in case you feel like you need to stretch a bit, go ahead, set your phone to flashlight mode, and you can, okay, you don't have to do that, but thanks. So I was really pleased earlier this morning when I heard one of our moderators, Tanya Fleming, talk about how important it is to address bad actors in the market and the importance of that for capital formation and protecting investment opportunities in this province. I think, as we talk about investor protection, I'm the director of enforcement at the ASC, and I have a natural inclination towards enforcement matters, but really passionate about what we do in enforcement and holding people accountable for securities misconduct, both because we're concerned about the individuals and the victims, and also because we're concerned about the impact of misconduct on the integrity and the effectiveness of our markets. I'm going to give you some case examples, some stories this afternoon. Before I do that, I want to talk to you a bit about where do we get our investigative leads from at the ASC? Where do our cases even begin from? They begin from a number of different sources. Lynn mentioned compliance reviews. So generally, compliance reviews result in compliance-related activities happening. Sometimes compliance reviews will identify deficiencies and concerns that are serious enough that the matter will be referred over to enforcement to do a deeper dive and investigation to see if any further action should be taken. We also receive complaints from the public, from investors or other members of the public. We receive information from industry members, folks like yourselves, industry folks and their professional advisors who say, I heard something, I saw something, this doesn't seem right. Do you guys want to take a look into this? We receive tips from whistleblowers, people who are working within a company where they suspect that there's securities misconduct going on, and they can bring tips forward to the ASC. And we also have staff within enforcement who are proactively doing our own investigative work to develop leads on potential investigations. I say all of those sources are welcome and all play a really important role in our ability to identify misconduct and hold people accountable with a view to stopping it, preventing it, deterring misconduct from happening again in the future. And Lynn talked about the spectrum of action that can be taken at the ASC. There's a spectrum of action that can be taken within our compliance areas and also within enforcement. And so, we issue warning letters. We can do an alternative enforcement action. Some of the cases I want to talk to you about today are ones where we've brought formal enforcement proceedings against individuals and companies. And we can bring those proceedings in a couple of different forums. One is we can make allegations where we bring a matter for a regulatory proceeding before a panel of ASC Commission members, where a hearing is conducted. If staff present the evidence, the respondents have an opportunity to present evidence, legal submissions are made on both sides, and then the panel makes findings. They find whether or not staff have established liability, and if so, they can go on to issue sanctions. The other way in which we can bring cases forward out of enforcement is through the courts. And we do so under two different pieces of legislation, one being the Alberta Securities Act, where we can allege an offense has occurred under our act, and the other is through our partnership with the RCMP. We have a joint team where those investigations can result in criminal charges under the criminal code on things that may be securities related. So we're talking fraud, market manipulation, insider trading. There are a number of different criminal code offenses that intersect with securities matters. So those are the different types of avenues we have available when we bring enforcement proceedings, and how we decide which avenue we're going to look at depends on the nature of the matter we're looking at. How serious is the misconduct? How have we dealt with this person before, or this company? Has that been effective? Do we need to move up the chain, so to speak, with the level of accountability that we're going to be applying? So I want to start, I told you I'd share some stories. I want to share two stories about some trials that were concluded this year that were involved ASC cases. And the first one involves a fellow named David Delbianco. And the ASC has been engaged with Mr. Delbianco going back to 2003, over 20 years now. He was first sanctioned by the ASC in 2003 for selling securities without registration and without filing a prospectus. So he entered into resolution with us at that time. He appeared on our radar again a number of times over the years, and in 2018, our newly formed unit with the RCMP, JSOT, or a Joint Serious Offences Team, conducted an investigation into David Delbianco, and we laid criminal charges against him. And in fact, I'll share with you that it's individuals like Delbianco that were the reason behind, they were the impetus behind the creation of this joint team with the RCMP to ensure that we could hold recidivists, people who are sanctioned and persevere in committing securities offenses, to ensure that we can hold them properly accountable and seek punishment where appropriate. So Mr. Delbianco was the very first case ever opened by JSOT, and in 2018 we laid criminal charges against him, charging him with fraud and money laundering. In a nutshell, the scheme that Delbianco and his partner were running is they were offering a legal services insurance company. So in essence, you would pay a monthly premium, just as you would for an insurance premium, and then when you needed legal services, you would have free access to those. Well, at trial, the evidence showed that this was nothing but a sham, that Delbianco and his partner raised over $500,000 from the public, but there was, in fact, no legal services insurance company. This was money that they had stolen from investors. In 2023, the judge, in finding Delbianco guilty of fraud and money laundering, described this as a shameful and cruel deception committed by this utterly remorseless fraudster. And I'd say I concur with that characterization with all that we've seen from him over the years. In December of 2023, Delbianco was sentenced to 4.5 years in jail and was ordered to pay restitution to the 7 investors who were victimized by his scheme. That's Mr. Delbianco. I'm going to take you to another story involving a gentleman named Ron Aitkins, who has also been long familiar to the Alberta Securities Commission and some other securities regulators in Canada. Ron Aitkins has been raising money in Western Canada going back at least a couple decades now for real estate-related development projects in Alberta and Ontario. At the ASC, we investigated him in response to making misleading statements to investors, and in 2009, Aitkins settled with the ASC. But a couple of years later, our colleagues in market regulation identified that Mr. Aitkins was engaged in conduct of great concern to us once again. So they referred that matter to enforcement. We conducted an investigation, and And in 2013, we filed charges in court under the Securities Act alleging fraud and misrepresentations against Mr. Aikens. It's 2013. Why am I talking about this case in 2024? I'll explain here. Before the trial could begin, counsel for Mr. Aikens brought a charter application in which he essentially alleged that under the Securities Act, the maximum punishment for each offense committed is 5 years less a day in jail and a fine of up to $5 million. And under the Canadian Charter of Rights and Freedoms, the charter says if you are charged with an offense for which the punishment is 5 years in jail or more, you're entitled to a trial by jury. So Aikens' lawyer said, well, it's 5 years less a day under the Securities Act plus a fine of up to $5 million. If you put that all together, it's really tantamount to 5 years or more in jail, and therefore my client should be entitled to trial by jury, and there is no such right under the Securities Act and the provincial court in which this matter is heard, and so these charges need to be stated. He lost at first instance and appealed this case all the way up to the Supreme Court of Canada. So off we went to the Supreme Court on this matter, and in 2018, the Supreme Court of Canada ruled no, the provision under the Alberta Securities Act and the similar sections that appear in regulatory acts, securities regulation across the country, is indeed constitutional. There is no right to a jury trial for Securities Act offenses. So the matter was then set down for a trial. We went to trial, produced evidence, and in 2020, the judge found that Aikens had indeed engaged in fraud and misrepresentations in relation to raising over $35 million through 3 offering memoranda. Aikens' lawyer then brought more applications before the court before we could get to sentencing, and was trying to have the trial reopened and was unsuccessful at each instance, but did succeed in delaying matters again considerably. So finally last year, in November 2023, the big day arrived and Aikens was scheduled to be sentenced. Our lawyer, our prosecutor, arrived there to court. Aikens' lawyer arrived in court, the judge was there, and no Ron Aikens. He was nowhere to be seen. Everybody turns to his lawyer and says, where is this fellow? He's supposed to be here to be sentenced. Judges wonder where his lawyer is. I don't know. He knows it was today. I thought he was going to be here. So we obtained what's called a bench warrant from the judge, a warrant for Mr. Aikens' arrest because he failed to show. We then took action immediately to have that converted into a Canada-wide arrest warrant for him. And we issued a plea through a news release with our communications colleagues that same day, plea for help from the public saying, if you have any information on Mr. Aikens' whereabouts, we at the ASC are interested in hearing from you. We received information, and we very soon learned that minutes before he was scheduled to be in court that morning, Mr. Aikens actually crossed the border into the United States in an effort to flee. We then put resources into working with other regulatory and law enforcement partners in Canada and in the United States. And over the next number of months, we're able to locate Mr. Aikens. And in August of this year, he was arrested in Montana. Not, as his lawyer told the court, speeding to the border to turn himself back into Canadian authorities. Good try. But through the collaboration with law enforcement between Canada and the U.S. He was arrested, brought back to Canada on what turned out to be his 70th birthday. And then brought before the court here in Calgary a few days later, at which point in time, he was then finally sentenced to 4 years in jail. We've been dealing with Mr. Aikens for over 15 years now on these securities matters, the offenses that he's committed. This one case alone has resulted in over 100 appearances in 4 different levels of court by our staff as prosecutors in this matter, and we're not done yet. Mr. Aikens has filed an appeal, and so we're now addressing the appeal. Why do we do this? Why do we invest these resources? Why are we passionate about holding people accountable? 2 words: investor protection. Just like the judge in this case found, Aikens is deceptive, he's manipulative, and he's extremely good at raising money. We need to stop him. He needs to be held accountable, punished for his conduct, and we need to ensure that the public is aware of individuals like Aikens. I want to talk very quickly, because we want to have time for questions. We're going to talk very quickly and change track to 2 different cases that we've brought for regulatory proceedings, cases currently before our panels. One that Samir spoke about earlier, a case called Black Box involving an individual named Mr. Craig Thompson from Alberta, who raised over $150 million for more than 1,000 investors in the span of 3.5 years, up until last year when we identified he was engaged in a Ponzi scheme and stopped the matter. I think about what we heard from some of the panelists earlier today and the challenges and the effort that's put into raising capital for great initiatives, like some of the ones we've heard about earlier today. And then I think about individuals who are engaged in fraud, people who are like this who are running a Ponzi scheme, where we talk about technology and social media, and one of the ways in which social media is being used is by word of mouth to spread fake investment opportunities. And so, we have individuals like this raising this kind of money with no financing costs, no commissions paid, no advertising costs, and this money in schemes like this is being stolen not only out of investors' pockets but out of our capital market. And so it's very important to us at the ASC that we bring proceedings forward on like matters with Craig Thompson. That case, the hearing has recently concluded just last week, and so we will await a decision at some point in the new year from the panel that heard that case. Have a second case that'll. No, I
Barely.
It depends how many questions you've all inputted. I'll just mention very briefly another case that we've brought forward called HW and Associates, where we've issued a notice of hearing, and this is a matter that involves unregistered dealing. I think it's an important one to mention because one of the ways in which we're seeing bad actors using AI and just the promise of AI is in unregistered trading. And so people are saying, oh, I am a superstar algorithmic day trader. I have, it's proprietary. I can't share with you this great AI that I have, but I can make you a fortune off of it. When in fact, they're not doing that at all. They may or may not be engaging in trading where they are. They may be engaging in very high risk trading and losing money for people. So it's one of the things that we're aware of. We're mindful of. We've brought allegations in cases. I was asked earlier today at the lunch break, what sort of trends am I seeing? One of my great observations in the years that I've been at the ASC is there's a lot of money moving much more quickly into the hands of bad actors and moving offshore. And so the need for us to be taking regulatory enforcement action, the need to coordinate with law enforcement agencies to take policing action where appropriate is more important than ever. So the very purpose of protecting our capital market and protecting legitimate investment opportunities that are here. Okay.
It's inevitable that enforcement folks are always enjoying telling war stories. And I can say that having had a litigation background, I'm well familiar with the disease.